Hey guys, today we are going to talk about pleading guilty. When an accused person chooses to plead guilty, it basically means that he accepts the statement of facts and the charges and admits that he has committed a crime. The choice to plead guilty must be voluntary and unequivocal. Lawyers cannot persuade their clients to plead guilty. But pleading guilty at an early stage usually represents genuine remorse. And the accused may get a discount of the sentence than if he went to trial and was found guilty. Because he would be wasting court resources by claiming trial when he's actually guilty. So by pleading guilty at an early point of time, he will be saving court time and resources, and he will likely get a discount. Although an accused can plead guilty at any time, even during the trial, pleading guilty at a later stage will usually not get the accused a discount of the sentence. Usually, what happens is the accused will get a court summons to appear in court. This is usually the mention court, the first hearing. The judge will usually ask if the accused does not have a lawyer, the judge may ask the accused to go find a lawyer or get legal aid. Or if a lawyer has already been appointed, the lawyer will usually ask for an adjournment, a postponement to take instructions from the client, and then ask for another date for further directions. So, after the first mention, what usually happens is the lawyer will write representations to the public prosecutor. Representation is basically a letter setting out the reasons why the charges should be reduced or should be dropped. When an accused faces multiple charges and the prosecution decides to only proceed with a few of the charges while the remaining charges are taken into consideration. What this means is that if a particular charge is taken into consideration, the accused will not be sentenced for that charge, but rather the judge will take into account the TIC charge when sentencing the accused on the other charges that are proceeded. It is therefore important that the accused understands the nature and consequences of his plea. After the representations are made to the DPP will usually reply within 3 to 4 weeks saying that no, we will not drop or reduce the charges, or yes, we may amend the charge, reduce the charge, or whatever. After that, the court will schedule a PG hearing, plead guilty hearing. So before the plead guilty hearing, the lawyer has to write a mitigation plea. Once again, it's another letter setting out the reasons why the accused should get a lower sentence. Basically telling a sad story. His mother died, grandmother died, he was beaten every day as a child, his wife has cancer, his wife left him, blah, 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 blah. He was in financial trouble, that's why he stole. He was in financial trouble, that's why he borrowed from the loan sharks and had to go and splash paint on the gate. These are mitigating factors. During the plead guilty hearing, the prosecuting officer will read out the charges against the accused and the statement of facts, to the accused. The statement of facts is a document that contains the material facts relating to the offense. Let me discuss. And the accused has to agree to every paragraph in the statement of facts, otherwise the plea will be rejected. Let me discuss this case with you. One of my clients was charged for failing to blow into the breathalyzer, Essentially what happened was he was very sick, He went for a vaccination and he was suffering from the side effects from the vaccination. So after he finished work, he was feeling sick, so he stopped his motorbike at the side of the road. And a traffic policeman, asked him to blow into the breathalyzer. He told the policeman he was feeling very sick, he couldn't blow. And then he got into an argument with the policeman. The policeman asked him to apologize. He refused to apologize. And according to him, The policeman, out of spite, stated in the statement of facts that the accused smelled of alcohol and admitted to drinking. So this was stated in the statement of facts. He was then handcuffed and brought to the police station. At the police station, he was again asked to blow into the breathalyzer. He said he was too sick and he vomited in front of the investigation officer. So, the statement of facts included a paragraph that he admitted to drinking and smelled of alcohol. During the plead guilty hearing, he suddenly disputed this. He was telling the judge, no, I did not drink, I did not smell of alcohol. I was a sommelier. I just sipped 3 glasses and I spat it out. And the judge said, no, I'm going to reject the plea. I'm going to reject the plead guilty plea because the judge would only accept it if he accepted the statement of facts. So we had to schedule another hearing. Then we went out, and after some discussion, he decided, well, since he's not charged for drinking, he's charged for refusing to blow into the breathalyzer. He decided to just admit to the statement of facts. As an aside, if the accused does not agree to any material part of the statement of facts containing the essential elements of the offence, the court may direct the prosecution to amend the charge or send the matter to the pre-trial conference courts for the matter to be directed for trial or a Newton hearing. Newton hearing is basically to decide on certain facts. The court can also ask the prosecution to amend the statement of facts. So on the assumption that the accused admits to the statement of facts, the defense counsel would then address the court on mitigation. Essentially, the mitigation plea, the one in writing, would already been read by the judge, and the lawyer then raises the salient points, the most important points, okay? It's very important that raising a possible defense in the mitigation plea could sometimes amount to qualifying the plea and may result in the judge rejecting the accused's plea of guilt. Let me give you an example. One of my clients was arrested at Woodlands checkpoint for using the words "what the fuck," okay, in front of an ICA officer. For those of you who are watching overseas, ICA is basically border control officers. The ICA officer wanted him to do something and he was not able to do it because the car door couldn't open. So he turned to his friend and said, "What the fuck?" And so he was arrested and charged, okay, for uttering the words. He was charged under the Protection of Harassment Act, Section 6, okay, for using indecent words to a public servant. So in my mitigation plea, one of the matters that I highlighted was that the phrase "what the fuck," okay, is an expression of frustration at the situation and not at the officer. And it was not directed at the officer. I also there was also some precedents, sentencing precedents provided by the prosecution, where the accused used the word "fuck you" to police officers. So I tried to distinguish the case, okay, for my client's case, saying that my client didn't use the pronoun "you," okay, unlike the other 2 cases. But the judge said that I was qualifying the plea, and then I had to amend the mitigation plea on the spot. I had to take out a pen, cancel the paragraphs relating to the part that my client was not directing the word "fuck" at the immigration officer. So, yeah. Usually, usually the accused is sentenced on the spot. If it's a fine, the judge will usually say, let's say 3,000 fine, in default 14 days prison. So you should always bring a NETS or credit card machine during your sentencing or plead guilty hearing, because they will, the police will escort you to the payment machine to pay the fine. If you do not pay the fine that day, they will bring you to jail. If the crime involved requires a jail sentence, then I advise you to bring all your necessary medication along to the plead guilty hearing. For example, if you have heart medication, HIV medication that you need to take every day, bring it along, because usually what happens after the sentencing hearing is that they'll immediately take you to jail unless you manage to persuade the judge to let you defer the sentence. So thanks for watching this video on pleading guilty.